A dilapidations claim is a dispute between a landlord and a tenant at the end of a commercial tenancy in relation to the state of repair that the tenant has left the building in. There are differences between terminal dilapidations claims and interim claims, because an interim claim is something that a landlord might pursue whilst the tenancy is still running, whereas a terminal dilapidations claim is a claim that is brought when the tenant has moved out of the building at the end of the tenancy. Common issues that are disputed in dilapidations claims usually obviously relate to the state and condition of the property. There is a myth on the part of tenants that if they have improved the condition of the property, then that means that there is no claim for the landlord to pursue. Also, it's very common for landlords to raise issues about the roof and its state of repair, and also frequently floor coverings can be a contentious issue. So the best thing that a landlord can do to protect its position if it has a tenant vacating the property is to send in a surveyor in good time before the tenant has moved out, give the tenant a schedule of dilapidations and allow them an opportunity to do the work. If the landlord gets the building back and finds that the works haven't been done, they can then get their surveyor to revise the schedule, and at that point the tenant doesn't have the right to go back in and do the work. It will simply become a financial claim. The best thing that a tenant can do to protect itself if it's moving out of a building is to engage its own building surveyor, get advice on what works they need to do in order to leave the building in compliance with their lease covenants, and to get on and do those works before they move out. Inevitably, if a landlord serves a schedule after the tenant has moved out, it becomes a much more expensive exercise for the tenant to put right. Diminution valuation is a very technical term that we use in the context of dilapidations claims. Essentially, a diminution valuation is when you look at the value of a property as it should have been left by the tenant and in a state of repair, and you then compare it to a valuation of the building as the tenant has actually left it, i.e. in disrepair. And the difference between those two values is the amount that the landlord can claim as a maximum in terms of damages. If you have a dilapidations claim, you should always act promptly because the court will expect you to have done that. But generally speaking, if you are pursuing a tenant pursuant to a lease, then it will have been signed as a deed and you have 12 years in which to bring a claim.